morning and welcome everyone, and welcome to those in the room as well as those joining us online. There are representatives from the media also joining us online as well. If there is an alarm, in the unlikely event that there is alarm, there are no planned safety briefings. There are no planned safety activities. So if there is an alarm, I'm going to ask you to proceed through the rooms at the left. Do not use the elevator, and you're going to go down the stairs, and we have a muster point at Renegades, which is across the road for those who are in the room. The restrooms are in the middle of the room. Lunch will be in the room adjacent to us, as well as there is a coffee break, so if you want, you can enjoy that. Unfortunately, we're not able to have that coffee break for those who are joining us online. So the goal for today, we wanted to provide you with a little bit of information about where the court is today, where it's going, and where it has come from. This is also an opportunity for representatives from the media to probe our judges and our guests, and let us know how we can help you make the reporting about the CCJ a little easier. So just a little bit brief about it. You would already have gotten the agenda, but just to go through. And we've been operating since 2005. A number of our judges who are with us have been here since that time, and some have joined us since. We are an appellate tribunal as well as we are an international tribunal as well as an appellate court. Our people come from all over the region as well as further afield. This is our newest judge, who is from Barbados, Andrew Burgess, and he joins the justices who are here today, as well as Dennis Barrow, who is not with us. So this was a picture we took when we launched our strategic plan a couple of weeks ago. And it shows almost in a very interesting way about our gender balance. We're about 50-50. And this included members from the RJLSC who were with us that day. Some of the commissioners were with us, as well as the judges and the staff. We're committed to serve the region because we live here and we believe in the mission of the CCJ. Contacting us is easy. So we're on Twitter, LinkedIn, Facebook. And right now we're streaming on YouTube, and we'll be doing a lot more with that channel in the future. These are the ways to contact us. We also have, through our email marketing software, an ability to send messages, which we do not as often as to annoy you, but enough to let you know about the major activities that is taking place at the court. So if you would like, please let us know that you would like to be included on that listing, and you can email us at pq@ccj.org. There is also another email address that we take those requests at, and that's info@ccj.org. We also have the 10th anniversary book here, which you may want to take a look at. The judges have them right in front of them on the stage, on their desks here. The CCJ book has messages and as from our former president, who was the president when that book was launched, as well as essays that discuss both the original and the appellate jurisdiction. It reproduces judgments in full, as well as their judgment summaries over the 10 years. Mr. Justice Hayton played a critical role in pulling that book together, and it's one of the activities that we wanted to do in order to continue to inform you about the work of the court. Throughout the years also, we continue through our annual report to give the judgment summaries so that you're aware of what is happening and you understand the work of the court better. But if you think that there is a way that we can serve you in a more comprehensive way, we also invite that as a part of the discussion today. We have been live streaming for about a year now, all of our court matters, and that's one of the things that we find very important. You can view hearings on premises at the CCJ as well. All of our hearings are also recorded, both audio and video versions, and they're on the website. So thank you for coming, and thank you for logging in. I'm now going to invite Mr. Garfield King, who will go through the day's proceedings and introduce our next speaker.
Good morning, ladies and gentlemen, and welcome, of course, to those in the room and those who are outside of the room in the Caribbean via the live feed. There will be several things happening today, but before, I would just like to draw your attention to a slight misprint on the agenda, and that's right at the bottom, highlighting the courtroom tour after the second question and answer segment. The courtroom tour is at 1:10, followed by lunch. So just to give you an idea of what to expect in this morning's session, there'll be a presentation from two esteemed guests, as well as brief presentations from the CCJ's president, along with 4 judges. Representatives from the court's IT unit and the registry will walk you through the technology that underscores and underpins the workings of the CCJ. We'll have 2, not 1, but 2 question and answer sessions, one after the 2 guests deliver their presentations, and the other will be after the judges speak. Questions can come from the room, as well as, of course, from those of you who are joining us via the live stream. And I know I don't really need to say this, but I will. Judges will take your questions, of course, but they cannot, I would like to repeat, cannot comment on cases that are before them. I don't need to repeat that, so I shan't. But that's clear for everybody. Then we will have a tour of the, as we said earlier, the underpinnings, the IT aspects of the CCJ, which are quite revolutionary, as you will see. And that will be followed by lunch as we wrap up. And as Charmaine said, the lunch will be, you can have the lunch here, some of you might want to take it with you, and you can enjoy it. So it is my pleasure to invite to the lectern the first guest speaker, and that will be Ms. Sophia Choate, SC, Independent Senator and Head of the Chamber, Alpha Chambers. Ms. Choate is a graduate of King's College London and Hugh Wooding Law School, and I invite her to come and join us. A round of applause would be nice. Thank you.
Good morning, all, and thank you very much for the opportunity to speak this morning. Perhaps before I begin my brief presentation, I ought to indicate my bias, which is to say that I am fully in support of the accession to the Caribbean Court of Justice by the jurisdiction of Trinidad and Tobago. So that is my position, having considered it over a number of years. So perhaps if you think that I am speaking about the court in glowing terms and that is affected by my bias, I want to give a disclaimer. While I do have that bias, I am a lawyer, and I have looked at the good work done by the court during the years of its existence. And certainly if I do speak of the judgments in glowing terms and talk about how impactful they have been on our jurisprudence throughout the Caribbean, I do so from perhaps the more objective perspective of a legal practitioner. So having said that, I have been asked to say a few words this morning about the original jurisdiction of the CCJ. Now, the original jurisdiction, if anybody wants to look it up, and I'm trying to avoid legalese as much as possible because we are speaking to a wider audience outside of lawyers and legal personnel and so on. So if anyone wants to look it up, you simply can go online and search up the revised Treaty of Chagaramas. It's pretty long, but if you scroll down to about Articles 210 and thereafter, 211 and thereafter, you will find the source of the jurisdiction, of the original jurisdiction of the Caribbean Court of Justice. Now, there are two articles which have played a particularly important part in the way in which the original jurisdiction operates. And those two articles are Articles 221 and 222. 222 has a particular interest for me, and if I may just read it out, because some of you may not be able to stop viewing the live feed to go and do your quick search on another device. So Article 222 talks about locus standi of private entities, and locus standi basically means the right to have a hearing or the right to come before a court. And what it says is persons natural or juridical of a contracting party may, with the special leave of the court, be allowed to appear as parties in proceedings before the court where the court has determined in any particular case that the treaty, I'm paraphrasing a little bit, intended that a right or benefit conferred by or under this treaty on a contracting party shall inure to the benefit of such persons directly. So that's one category in which you can come before the court invoking the original jurisdiction. B, the persons concerned have established that such persons have been prejudiced in respect of the enjoyment of the right or benefit mentioned in paragraph A, and the contracting party entitled to espouse the claim in proceedings before the court has omitted or declined to espouse the claim, or expressly agreed that the persons concerned may espouse the claim instead of the contracting party so entitled. And the court has found that the interest of justice requires that the persons be allowed to espouse the claim. Now, having just said that I'm going to avoid legalese, I would imagine that that is quite a mouthful for a lawyer, so it must be a bit difficult to follow for a lay person. But to break it down a bit, I think one of the important things that we need to recognize is that an individual has access to the Caribbean Court of Justice in certain circumstances. And an individual doesn't have to wait to say, or may not have to wait to say, well, I can't go to my courts before I come to the Caribbean Court to ask for its original jurisdiction. Now, that is putting it very, very simplistically. But I think for the purposes of this morning's session, where we are trying to make sure that everybody understands what the court is about and how it operates and so on, I think perhaps those two things are quite important. Now, what I would like you, if you're following online and so on, is if you go to the website of the Caribbean Court of Justice and you just click on judgments, you will see that the judgments are separated into appellate and original. I think there are many more appellate cases heard since the court started sitting, but there are some very interesting original jurisdiction cases which you may want to look at. And what makes it easy if you do that is that you don't have to go and read the whole judgment, because sometimes it's quite a lot to take in. But there is often an executive summary of the judgment on the website that you can click on and get an idea of what the case is about. Why I'm emphasizing that we ought to do this kind of thing and do these step-by-step searches is because I think that those who somehow express the point of view to say that the Caribbean is not ready for the Caribbean Court of Justice tend to express views, perhaps I should say, without having looked at the work of the Caribbean Court of Justice itself. And they base their opinions perhaps on old affairs. They think that the judgments of the Caribbean Court will not be in line with the rule of law, will not give the kind of quality that you expect from international tribunals or foreign tribunals and so on. And if someone were to go on that website and look at simply at the executive summaries for the cases on the original jurisdiction, cases heard invoking the original jurisdiction of the court, you would see that all of those fears may be allayed. Now, I can't understand why people would be afraid of a Caribbean court after it has been producing excellent product from its inception to now. For some reason, there are still those who think that we are not good enough to adjudicate on our own matters. There are those who think the Caribbean Court of Justice is a step up, it's a promotion from local courts to the Caribbean Court. Wrong. There are those who think that the quality of the work done by the Caribbean Court of Justice, whether in its original jurisdiction or otherwise, will be inferior to the work produced by other courts. If you go to have a look at what the court has produced in its original jurisdiction, you don't have to take it from me. I don't have to go into cases and tell you how wonderful the judgments were. Take a read for yourself. We can only make a decision which is an informed decision if we take the trouble to do the work, to look at the product. And I think that is very important. Now, I have been asked to refer to a few of the cases in my contribution, and I hope there is a timekeeper here because I have not been keeping time. And will you be good enough to let me know when I have 5 more minutes so that I'll be able to wrap up? Now, the original jurisdiction of the court has considered many aspects of the law. And I suppose the temptation for me was to go for one which looked at human rights issues, but I won't. I think the first one I'll look at is the case of SM Jalil and Company Limited and Guyana Beverages Incorporated and the Cooperative Republic of Guyana. The reason I do that is because one of the things people had thought about this Caribbean Court of Justice was that businessmen would be afraid of having their matters adjudicated in this Caribbean Court of Justice. I think this case shows that that fear, if it still exists, that fear must have been dispelled after the adjudication of this case. SM Jalil Company Limited is a company incorporated according to the laws of Trinidad and Tobago. And I think their subsidiaries, Guyana Beverages Incorporated, I believe, may have been one of its partners or subsidiaries. I can't now recall. But this had to do with a question of whether the state of Guyana, the Cooperative Republic of Guyana, had the power to collect certain taxes from SM Jalil. Now, please accept that I'm simplifying the facts of the case. And SM Jalil was basically saying that no, at the time when you collected these taxes, essentially you had no right to do so. So could I please have my money back? And Guyana was saying, well, sorry, no, for various reasons. We think that even though we may have collected the taxes at a time when you didn't have to pay it, well, too bad. I don't know that you can now come and after all this time and claim that you ought to be repaid the money. And one of the things that the court considered was the issue of unjust enrichment by the state of Guyana. And it's actually interesting reading for me because it is not an area of law that I normally read about. But when you look at the judgment, you see that the court is fully aware of the economic tensions which may exist between companies doing business and a state entity. And the court was able to look at the law very deeply and to determine at the end of the day that the private company was entitled to be paid back the monies which had been incorrectly paid. So look at it because it deals with commercial aspects, or I should say, business aspects of law, and it shows you that business entities can come to the Caribbean Court of Justice through an invocation of its original jurisdiction, and they can get a well-considered analysis of their case, and they can get justice, because this is what it's all about, justice in accordance with the rule of law. So, having stepped out of my crease a bit by talking about a case involving business law, perhaps I should go back to one which is, oh dear, I think I'm pressing on the somebody else's presentation. I'll just try to step to the side. Okay. Now, some of the cases, I don't know if SM Jalil's case made it to the newspapers, but some of the cases which make it to the newspapers deal with human rights issues. I think perhaps because it's more interesting when you hear about a little bit of bacchanal forming the facts of a case. So I am sure that if you ask anybody who's been following these 5 minutes, right? If you've asked anybody who's been following the work of the CCJ, if you've heard of any of the cases or any of the decisions, one of the decisions might be the case of Shanique Myrie, I believe it is, CCJ application number 2 of 2012, and this was brought by a Jamaican citizen against Barbados. And this was where a national of Jamaica, a Jamaican citizen, had gone to Barbados and had, let me see if I can find the correct part of it, just so that I won't be inaccurate. She had gone to Barbados, and the immigration department there, I believe, had sought to refuse her entry. And there had been, I suppose, for want of a better word, some kind of altercation about her entry. And I think if you want to look at how the court considers the law in relation to human rights, this might be one of the cases that you might consider. Everybody's talking about Jason Jones, by the way, because it is one of the more recent decisions. And I think one of the things you can do in looking at cases like these is you will look at it and you will see a thread of reasoning running from start to finish. And it is the reasoning which I commend and which I personally find sterling, because it is reasoning which uniformly respects the rule of law. It is reasoning which uniformly respects our legal obligations to our international partners, not only in the CARICOM region, but also by referring to other courts and their interpretation of what amounts to human rights and what amounts to the rule of law and so on. It ties us in very tightly with a high standard of protection for our citizens in the eyes of the world. So I know that I was asked to refer to cases, but I thought to myself, well, who wants to hear a lawyer read out cases, right? That is not going to be very interesting. So I've tried to pull from some of the cases what I thought may be useful or which may be interesting for the listener or the viewer to go to search up or to read about afterwards. So certainly, by all means, if you want to see how businesses can get justice before the Caribbean Court, Jalil might be a good case to read. If you're more interested in the human rights aspect of it, read up on Shanique Myrie and Jason Jones. Another case of interest that you may want to look at, because I'm running out of time, is that of Trinidad Cement Limited, TCL Guyana Incorporated, and the Cooperative Republic of Guyana. So I think that I will not bore you further. I saw that my hand went, there was a hand that went up at the back indicating to me that I was close to my end of time. And I know that in Parliament, when you reach the end of time, you simply have to sit down, even if you are in the middle of a sentence, and I don't want to get there. So first, I want to thank you all, the members of the CCJ and your secretariat, for inviting me this morning. And I trust that I have accomplished what you hope to do, which is to say, try to send a message to the wider viewing population, wider listening population, about the original jurisdiction of the CCJ. It is a lot of legalese to handle, but I hope that I've been able to show you some tools or mechanisms you can use so you can find out for yourselves. You don't have to take it from me. And I think it's important for our Caribbean citizens to be informed and to appreciate what the principles are in relation to the Caribbean Court of Justice. Thank you very much.
Thank you very much, Sophia Choate, SC, Independent Senator and Head of Chamber at Alpha Chambers. Very comprehensive, and thank you for the examples and pointing us in a direction that we can for ourselves see some of the work of the CCJ. I'd like to invite our next speaker, Dr. Indira Ramprasad, political scientist, media commentator, and lecturer in political science, international relations at the University of the West Indies, St. Augustine. Many of you will have seen her on television commentating politically. Or let me correct that and say commentating on political events and providing very interesting insight. So please, I'd like to invite to the lectern, Indira Ramprasad.
Thank you very much, Chair. Honorable President of the Caribbean Court of Justice and honorable judges of the CCJ, Justice Anthony Gafuru, Chairman of the Tax Appeal Court of Trinidad and Tobago, members of the media, CCJ staff, invited guests, I see my colleague from UE, Professor Rajendra Ramlogan. Ladies and gentlemen, pleasant good morning, and I wish to thank the CCJ for this opportunity once again to address you and to address the media. I was invited today to speak on the impact and contribution of the appellate jurisdiction of the CCJ to Caribbean society. My overview slide, as you would see, outlines the structure of my presentation. So I'm going to look at the background to the CCJ's appellate jurisdiction, the relevance of cases in the CCJ's appellate jurisdiction, major contribution of the appellate jurisdiction cases, and finally I will end with some recommendations. So I will start by emphasizing that the CCJ was established with dual objectives in mind. And that is in the slide there. You will see the two objectives. They are underscored in the preamble of the revised Treaty of Chaguaramas, the RTC, and the treaty establishing the CCJ, both enacted in 2001. While the goal of deepening the regional integration process through the Caribbean single market and economy has been emphasized and is of particular relevance to the original jurisdiction of the CCJ, the first objectives of those who envisioned the Caribbean Court, an idea which dates back way to 1901 and it again surfaced in 1947, was to foster an indigenous Caribbean jurisprudence. With the independence movement of the 1950s and 60s, this objective became coterminous with completing the circle of independence, and that was popularized by former CCJ Judge Justice Pollard, who actually has a book with that title. That means creating an autonomous court to replace the Judicial Committee of the Privy Council. And so the original or first objective behind a Caribbean court was to foster an indigenous Caribbean jurisprudence through a final appellate regional court. The idea of promoting regional integration came after this first objective. It was an effort to emulate the then European Court of Justice and its own efforts at regional integration through the European Economic Community and the European Union, which, well, it's now the European Union. So the CCJ emerged in the post-Cold War era. It was established in 2001, inaugurated in 2005. This was a time when regional and international courts were flourishing around the world because the end of the Cold War gave rise to objectives and the development of legal norms in like democracy and justice and the promotion of liberal ideals. But the question still lingers, which I have on this slide here, as to whether merely delinking from the Privy Council and subscribing to the CCJ constitute the establishment of an indigenous Caribbean jurisprudence. So unlike Sophia, I'm not being biased. I am coming here as an academic with an independent position. However, achieving this objective has been challenging because, and you're going to see in the next slide, so far, only 4 Caribbean states have subscribed to the appellate jurisdiction of the court. The slide lists the Caribbean members, the CARICOM member states, and you're going to see those in blue are the only ones, and it's kind of difficult for you to read them there, but they are Guyana, Barbados, Dominica, and Belize. Those are the only states that have subscribed to the appellate jurisdiction of the court. Those in well, the colors have changed, but those in white there are actually those still subscribing to the Privy Council. And I also have a structure of the court system. This is basically guided by the doctrine of stare decisis, which is that higher courts bind the lower courts, and we move from the magistrate court, the high court, the court of appeal, and then we have 2 streams, the CCJ on the one hand, which is the Caribbean court, the Privy Council, London-based, which is also an appeal court, those in white subscribing to the Privy Council, those in blue subscribing to the Caribbean court. So we have four states subscribing to the Caribbean court, yet we have almost 150 cases in the appellate jurisdiction of the court and 21 in the original. It's a very interesting phenomenon that 4 states have brought almost 150 cases, 7 times almost the amount of cases that are in the original jurisdiction. So I think that is something we want to take note of, and probably something we can analyze. But achieving this objective has been challenging. Achieving the objective of getting states to subscribe to the appellate jurisdiction, one would have to examine the jurisprudence of the court. And I'm saying I came independently here. I have surveyed, and I've had the task of looking at these 150. I didn't look at all of them, to be honest, but a lot of them. And the ratio, I have to say, the reasoning are extremely sound throughout. I've also looked at some of the original jurisdiction cases. There's only one ratio I didn't agree with, but I can see the court's position, and that was Cabral Douglas. I didn't totally agree with that ratio, but the rest of them, and the reams and volumes of information there in the different opinions of the judges, attempting to reason the cases, which I think they have done an excellent job of. So to look at some of these cases, I have basically divided them, and you would see in the next slide, I have divided them into 4 categories: the land law and conveyancing matters, constitutional matters, criminal appeals, and human rights. Now, these are not clear-cut because they're, one can discern certain significant overlaps between them, so it was really difficult to categorize even. But turning to land law and conveyancing, we don't need to emphasize the significance of land to the Caribbean population. I mean, there are numerous land issues, particularly emanating from Guyana. Ramdale and Hiralal, 2009, is seminal in the sense that the human and law students actually have to cram this for their exams, because it really it serves as a lesson for all potential purchasers who have entered into an agreement for sale of land, that they should file a caveat in the land registry to protect their own interests. And this applies to several Caribbean countries and also Trinidad and Tobago, which is not a member of the appellate jurisdiction. Section 125 of the Real Property Act mentions need to, or the wisdom in filing a caveat. The other case, Tulsi Prasad and Andrew James Investment Limited, speaks on the issue of adverse possession. And normal parlance, this is squatting. I think that's the word we use normally. So in this case, a landowner can bring an action to recover his land from the state, which was in adverse possession of the land under a compulsory acquisition order. The landowner succeeded as the compulsory acquisition order was held to be invalid by the CCJ. The other case, the Maya Leader Alliance case, and the Attorney General of Belize, I find this very interesting because it deals with, to some extent, cultural rights. And it confirms the Mayan customary land tenure rights fall within the ambit of the Constitution of Belize and are protected by the Constitution. It speaks volumes for the protection of not just of citizens' rights, but minority and indigenous people's rights to land, which was rightfully recognized by the Belizean government. So that was not the issue. The issue at hand was the award of damages. Although the Mayan Alliance failed to secure pecuniary damages, and I perfectly agreed with the CCJ ratio there, the court ordered the Belizean government to establish a $300,000 Belizean fund to protect the Mayan land rights and to pay 75% of the costs of the action. And constitutional matters are very close to my heart as a political scientist. The CCJ was determined to uphold fundamental rights as enshrined in the constitutions of the Caribbean territories. And this stands out, this desire, this determination to uphold the fundamental rights as enshrined in the Constitution. It pervades these cases. It was evident in the Mayan case, which I just discussed, and also a constitutional matter. But in Attorney General and Barbados and Joseph and Boyce, this famous or infamous case, as it may, was held in order to assure a condemned man the right to the protection of the law. A constitutional ouster clause did not prevent the courts from inquiring into the decisions of the local mercy committee. The CCJ also held that a condemned person had a right to petition the relevant international human rights bodies and to have the reports of those bodies received by the CCJ and considered by the state prior to execution. The Inter-American Court on Human Rights was also chastised for its delay in delivering reports from prisoners on death row. And it's interesting, the court has been very bold in reprimanding the local judiciary in Barbados in particular, and other territories, for delay. And this is evident in the cases of Gibson and the Attorney General 2010, and Katrina Smith and Albert Anthony Peter Selby 2017, because they have been on inordinate delay in the hearing of local matters. The Attorney General of Guyana and Cedric Richardson, 2017. Very interesting. It's a political case. Cedric Richardson, citizen of Guyana, he wanted to bring an action. He brought an action because he claimed that his rights were being infringed because Barra Jagdev's term was limited to 2 terms. Now, this was a decision of the National Assembly, of which Barra Jagdev was a part at the time, but he is claiming that his fundamental rights were infringed and were diluted by the amendments which stipulated these 2 terms. The CCJ argued that the amendments were designed to ensure that Guyana remains sovereign and democratic. This decision can have far-reaching ramifications for Guyanese politics. And again, as a political scientist, I agree with that decision. I agree with the ratio. And the whole idea, we have to understand Guyanese politics and the history of Guyanese politics, which is well documented in that case. Remember, Guyana is the only English-speaking territory in the Caribbean with a different system of governance, proportional representation, unlike the others, those of us who are parliamentary democracy. So that would have been a repercussion of that change that Guyana made. That Cedric Richardson's case. Like I said, it have far-reaching ramifications for Guyanese politics. And then came Eddie David Ventors, and the Chief Electoral Officer 2018, that's just last year. Another case which is emphasizing democracy, norm which the CCJ, I notice, has been attempting to promote. A Commonwealth citizen, resident in Barbados for more than 3 years, was denied the right to vote and have his name on the electors list, even after the domestic court ruled that he was illegible. The Constitution states that once you have been in Barbados for 3 years, and you're a Commonwealth citizen, you have the right to vote. So the CCJ ordered the Chief Election Officer to have Professor Ventors registered. By 12 noon the next day, the CCJ held a historic sitting on a Sunday, ordered the Chief Electoral Officer to have him registered. Otherwise, she would be held in contempt of court. I gather that she did oblige. And then we want to look at Macruan and Guyana 2018, the CCJ addressing the merits of certain savings clauses in the Caribbean constitutions, affirming that no one should suffer from the oppressive effects of such clauses unless the provisions which they protect are legally certain. The preservation of such a clause as giving rise to immunity from suit was rejected in this case in relation to vagrancy laws which had existed since 1893. And these vagrancy laws themselves had been amended and amended and amended. So there was I don't know why they were still called saving clauses. And it was challenged by certain members of the LGBT community in Guyana in terms of the right to cross-dress. The appellants succeeded in their appeal, a decision which would have significant social implications for the transgendered community in Guyana, the LGBT community on the whole, because they were represented by an LGBT body, which were allowed also in the decision. And now I want to turn to criminal appeals, but very, very briefly. I know I have limited time. Did you put up your hand there? I know I have very limited time. So what I'm going to say is that these cases dealt with special leave granted to prevent a miscarriage of justice. It dealt with the issue of the accused being given the right to be heard, the natural justice. And it dealt with sentencing. And the CCJ emphasized that the lower court should consider the time spent in remand when they are looking at sentencing. So that has to be included in that time frame. The Caribbean society may not be very pleased with these decisions, particularly these criminal appeals which uphold the rights of the accused or prisoners. Remember, the citizens too. But the CCJ is simply continuing in the vein of protecting the rights of the region's citizens. So to conclude, the CCJ claims that it is not a human rights court. Now, Anthony and I were in a conference in Chicago, and this came up. We did bring this up in terms of Tomlinson. I think that is where the statement was made. And also in Myrie, I recall, I was actually here for the sit-in, that the court did not consider human rights issues in Myrie, body cavity search and all that. But it is true that the CCJ is not given this mandate in the revised Treaty of Chaguaramas and in the original jurisdiction. But one can discern several cases in which the court flirts with the issue, particularly in the appellate jurisdiction. And we have a list of those cases here. I have identified them. The issues, like I said, arose in both Myrie and Tomlinson in the original jurisdiction, and in some of the cases I have reviewed. Now, this reluctance to embrace human rights is discerned with the European Court of Justice, which claims that human rights is the purview of the European Court of Human Rights in Strasbourg, France. But the Court of Justice of the European Union, which it is now called, has engaged issues on several fronts, including the individual rights to privacy and the effectiveness of asylum policy. The court has also looked at freedom of religion, and that is paradigmatic, because the court in scarcely 2 years has been confronted with the interpretation of the Charter's rules on freedom of religion and equality in cases concerning the use of headscarf in the workplace, the use of private slaughterhouses for the Islamic feast of the sacrifice, the collection of private data by Jehovah's Witnesses when preaching on the doorstep, or the recruitment criteria of management based on the grounds of the candidate's religious beliefs. The European Court of Justice, or the Court of Justice of the European Union, could not, like the CCJ, avoid these human rights issues. So the CCJ cannot evade its destiny to engage in human rights issues. There's also a thin line between some of these fundamental rights, which it has desperately been trying to protect, and human rights. My first recommendation, therefore, and I now go to the slide on the recommendations, is that human rights is an issue which the court must boldly embrace, as some human rights concerns of Caribbean citizens are unique to the region. For example, oppressive savings clauses in their constitutions. I will stop there, but I could write a paper on this. My next recommendation is a revision of the revised Treaty of Chaguaramas. I think it's time. Why can the CCJ not treat with organs or agents of CARICOM? And I know it's been linked to the ICJ and all that, as it does with CARICOM institutions. By being circumscribed by the RTC, the likes of Jason Jones would be left without recourse against certain regional institutions, which are a law unto themselves, and we know who they are. Perhaps the human rights issues can now permeate Caribbean societies like an incoming tide, Sir Dennis's words, flowing through the Caribbean region and moving up the Caribbean Sea. It cannot be held back. Thank you very much.
Thank you very much, Indira Ramprasad, for an incredible historical perspective, as well as explaining the significance of some key cases and their impact and implications for the Caribbean. Now's the time we have our first, I just received a signal. We have our first question and answer session, and we are opening the session for our participants on the live stream firstly, as well as the media in the room. And the questions, of course, will relate to the two presentations we've just had from Ms. Choate and Dr. Ramprasad. And I believe a question has already come in.
Someone is asking Dr. Ramprasad to talk a little bit about the savings clause and what that means.
These were clauses in the Caribbean constitutions pre-independence, and they were there in order to protect certain constitutional rights of Caribbean citizens. Post-independence, the Caribbean leaders, and I mean throughout the region, thought that it would be important to keep these and not change them in the Constitution, even though the constitutions had been revised, well, with the development of the constitutions, that it would be important to keep them in order to preserve those rights. However, we have found, as in the case of that vagrancy law, that some of them turn out to be oppressive. And it was in this context that the CCJ ruled as it did in that McCrean case. So basically the savings is to save the good aspect of these clauses, but sometimes they're anachronistic. They don't move with the times. Remember, they're pre-independent, so we've gone a long way, and it's sometimes necessary, I think, for us to review some of these savings clauses. I hope that I've clarified it.
Any other questions during this session? From another question coming in from the Caribbean?
Someone is asking, and this one is for Ms. Choate, about Myri and the fact that we are still having issues with freedom of movement. What are the things that are being done to address it? I don't know if one of the judges would prefer to answer that, or Ms. Choate, if you would.
Is it, just asked from a technical point of view, is it better for the questions to be answered from here or from this mic? Or it doesn't matter? Okay.
Well, I think we have to understand what a court can do. A court can interpret law and apply law, but at the end of the day, the movement of citizens throughout the Caribbean will be governed by other agencies unless there is a problem and it's brought before the court. So I don't know that the CCJ, well, I am perhaps speaking out of turn here, but I don't know that the CCJ is in a position to express a point of view, generally speaking, about the movement of CARICOM citizens. That's just my take on it. I could be wrong.
Would any judge,
Yes, thank you, Chairman. I agree entirely with what was just said. The fact of the matter is that the court adjudicates on cases that come before it. And we seek to ensure that our adjudications, our judgments, are followed, are complied with by the relevant member state. In the case referred to earlier, the judgment we gave in favor of Ms. Shanique Myri was completely complied with by the government of Barbados. If there are other CARICOM nationals who have difficulty in enjoying their right to move freely in the countries of the region, then of course they can approach the court, and if they satisfy the standing requirement mentioned by Ms. Choate earlier, we will hear the case and grant a judgment. Of course, it would be useful if the member states observe the judgments, not just in relation to the cases which are brought against them, but generally, and put in place procedures which respect the right of freedom of movement. But as was said, the court cannot go out of its grease to make any pronouncement about procedures in relation to matters which were not brought before it for adjudication.
I also want to add that not only can you go to the CCJ, but you can go to your domestic court. And if there is a matter that needs further interpretation, then that court can refer the case for that particular point to the CCJ. So it's not just that you have to go to the CCJ to get a solution with a matter like this. You can also go to your own court or to the court of the country where you were not treated correctly, and refer to the jurisprudence of the court.
Thank you, Mr. Justice Witt, and before him, of course, Mr. Justice Anderson replying to that question. Any other questions coming in from the live stream at the moment? Any questions coming from the media in the room at the moment? Any of the judges want to make a comment? You'll have an opportunity. They will reserve judgment, I believe, yes?
Well put.
Okay, so in light of that, we can move on to our next session. And the next item on the agenda is basically we're asking the President of the CCJ, Honorable Justice, Mr. Justice Saunders, to deal with this topic for us. So I invite to the microphone Mr. Justice Saunders.
Thank you very much. My colleague judges, our distinguished invited presenters, Ms. Chote, Ms. Rampasad, Chairman of the Tax Appeal Board, Mr. Gafoor, our registrar, Mr. Ram Logan, professor at the University of the West Indies, other distinguished persons present, staff of the court, and those of you who are looking at us on the live stream. My presentation, which wouldn't take me very long, seeks to answer the question, why the CCJ? Whenever I present myself before audiences throughout the Caribbean, the question that immediately comes up is, well, why are there only 4 countries that have acceded to the appellate jurisdiction? Why is it that the states of Trinidad and Tobago, Grenada, St. Lucia, St. Vincent and the Grenadines, Antigua and Barbuda, St. Kitts and Nevis, Jamaica, and to a lesser extent Bahamas, because Bahamas has not signed the treaty establishing the court. But why is it these states still send their appeals, their final appeals, elsewhere? Why should they send their appeals to the CCJ? Well, like Ms. Chote before me, I'm naturally biased in the answer that I would give to the question. But even introspecting, looking at all the reasons that I've heard and trying to be objective about the matter, I have not heard a single reason that persuades me that it is a good idea to send the final appeals of any of these countries to a tribunal other than the Caribbean Court of Justice. And so I want to discuss that issue a little bit. This image for me is a tapestry. And it is an image that for me represents the law. I see the law as an overarching tapestry of rules, of statutes, of regulations, of judicial decisions, of settled state practices that constrain our choices, that promotes our human dignity, our human rights, that protects us from anarchy, from despotism, from misrule, and that promotes our welfare and our happiness, this overarching tapestry of law. And as you would see in the image, that tapestry contains fine print. It has dark corners, dark crevices, obscurities. It has recesses that you can't see quite clearly. The role of a court is to fill the gaps that exist there. It is to illuminate the dark recesses. It is to shine a light on the obscurities, to flesh out and bring to the fore the fine print that you see there. And courts do this when parties bring matters before the courts. It is not the job of the Parliament or the job of the executive to perform any of those roles I just mentioned. It is exclusively the role of the courts. So that when parties bring proceedings before the courts, they're not only asking the court to resolve a personal dispute they have between themselves. They're doing something that is of even greater importance, especially if the dispute resides in the realm of public law. That is to say, in matters that touch on the criminal law or judicial review of legislation or of executive action, or matters that have to do with human rights or constitutional law. Because in the course of resolving the dispute between the litigants who are appearing before the court utilizes that opportunity to shine a light on the obscurities that you see in that tapestry. The court takes the opportunity to fill in the gaps that you see there. The court takes the opportunity to let the public understand the meaning of the fine print. And that role that the court plays is naturally one which is best executed by judges who are immersed in the society from which the dispute emerges. And that brings us to our second slide, which I have entitled, Seeing from Near, Judging from Far. I deconstruct the art of judging into two basic elements. The two things which a judge must do is, and I speak of any judge, a judge at Panorama, a judge at a beauty contest, a judge in the court. A judge must be able to see from near and to judge from far. The judge must simultaneously be near and far. How you explain that paradox? Well, to be most effective, the judge needs to be at the front and center of the contest or dispute as it is unfolded before the judge. And as you will notice, whether at Panorama or at a beauty contest or in the courtroom, the best seat in the house is always reserved for the judge. But seeing from near involves more than just where you sit. Seeing from near implies a cultural nearness. Ideally, the judge should have knowledge of and be immersed, as I said before, in the culture that gave rise to the dispute. The judge must, so to speak, be on the same page with the persons involved in the contest, the persons who have the dispute. So you can have, for example, wonderfully trained musical adjudicators, but I'm not so sure they could be very effective at judging Panorama if they're sitting in Paris or in London and struggling with the expression of what exactly is hooking me means, or if they are struggling with why is it that persons who play steel band have such an expressive flair about them when they play music. I am not so sure that a judge in that context will be as effective as a judge in Trinidad sitting down in front of the Panorama as it unfolds. So this is what I mean by saying that a judge must be able to see from near But it is also true that a judge must simultaneously judge from far. And what I mean by that is that not that the judge must be geographically distant, but that the judge must be detached, removed from the situation. The judge must not get so personally drawn into the contest that she or he is improperly influenced by his or her proximity to the dispute. The judge must be unbiased, impartial, dispassionate. So what we really mean when we say that the judge must judge from far is that the judge must be impartial. Now, it is true that distance, physical, geographic separation from the site of the dispute might lend itself to a certain level of objectivity. And that is what some people might like about a tribunal that is thousands of miles away. The truth, however, is that objectivity, impartiality, are mindsets that any judge worth her salt easily demonstrates. You don't need to be physically distant in order to be impartial. And indeed, you can be physically distant and partial. But it is certainly not possible to be physically distant and to be able to see from near, to be able to be immersed in the culture and the norms and the values and the aspirations and the goals of the people whose dispute you are adjudicating. Now you would see the images of two persons on the screen. And those of you who are Trinidadian would instantly recognize the faces of Mr. Ken Gordon and former Prime Minister Basdio Pandey. And those images are there because there was a case between these two gentlemen that, in my view, vividly demonstrates that concept of being able to see from near and judge from far, and the importance of a judge being able to combine these two elements in order to render a perfect judgment. Mr. Gordon brought defamation proceedings against Mr. Pandey because Mr. Pandey had labeled Mr. Gordon a pseudo-racist. In Trinidad and Tobago, pseudo-racism, pseudo-racist might have a particular connotation. It is, some might say, a fractured society where race relations are something that is talked about. The trial judge agreed that it was a terrible thing for Prime Minister Pandey to call Mr. Gordon a pseudo-racist. And the judge awarded Mr. Gordon damages of about $600,000. Mr. Pandey appealed and he lost because the Court of Appeal said that the term pseudo-racist was indeed libelous and therefore he was liable for defamation. Mr. Pandey complained about the damages. He said the damages, it was just too much. $600,000 is a lot of money. And the Court of Appeal agreed, and they reduced the damages by half, to $300,000. Mr. Pandey appealed further to the Privy Council, which of course is based in London, thousands of miles away, and which is staffed by British judges who are not Trinidadian and who don't live in Trinidad and Tobago. And Mr. Pandey had two grounds of appeal. Firstly, he said, well, you know, it's not a big thing in Trinidad and Tobago to call someone a pseudo-racist. In Trinidad, there's this thing called pecan. And, you know, people say things and so on, and Mr. Gordon was just being oversensitive. And the case should be dismissed. The judge and the Court of Appeal got it wrong in thinking that this harmless expression could be regarded as such a dangerous libel. And secondly, Mr. Pandey argued that, well, if you don't agree that the case should have been dismissed, then the $300,000 in damages which the Court of Appeal ordered, having reduced the trial judge's figure, was still way too much, and the Privy Council should further reduce that amount. Well, what did the law lords say? On the first issue, they said, well, the judges of Trinidad and Tobago are in the best position to assess whether in Port of Spain it is a bad thing to call someone a pseudo-racist. And so they were not going to reverse the judges of the courts below on that point. As to the amount of the damages, I will quote you exactly what the judgment said. It said, quote, "The seriousness of a libel and the quantification of an award are matters where judges with knowledge of local conditions are much better placed than we are to determine." In effect, the court was saying to Mr. Pandey, we can't reverse the judgment of the Trinidad judges because we are unable to see from near. And therefore, the decision of those judges must stand. Appeal dismissed. My point is that good Caribbean judges are always able to judge from far, even as they are always able to judge from far, even as they are best placed to see from near. And that it is therefore important for us to recognize that effective judicial decision-making is best able to emanate from courts that reside in the region. And this is not something that I am saying because, as I said, I have a bias. I'm the president of the Caribbean Court of Justice. It is something that is recognized as well, even by those persons who are on the Privy Council. In 2003, Lord Hoffman, one of the fine judges of the Privy Council, he told the Law Association of Trinidad and Tobago, and I quote, "The CCJ is necessary if Trinidad and Tobago is going to have the full benefits of what a final court can do to maintain democratic values in partnership with the other two branches of government, the executive and the legislative." He wasn't alone in this respect. There is another quote I want to put up on the screen, which speaks pretty much to the same thing in constitutional matters in particular. And this judge said, this jurist, a judge sitting in a local constitutional environment in which he's grown up, and with which he's familiar, is likely to have a surer sense of what falls within the purview of the Constitution and what falls beyond than a court sitting many miles away. This judge was in effect saying, look, in constitutional matters, Caribbean judges are in a much better placed position to offer a view of the interpretation of the Constitution that is better than a judge that is sitting many miles away. And who said that? Well, this wasn't said by a Caribbean judge. This was said by Lord Bingham at the time he was president of the Privy Council of the UK Supreme Court. And he said it in a case called Surat against the Attorney General, which was decided on the 21st of July, 2008. And so it is my view that the states of Barbados, Guyana, Commonwealth of Dominica, and Belize are enjoying a tremendous advantage over those other states which I've mentioned. An advantage which, as has been indicated by Ms. Rampasad before me, is demonstrated first in the volume of cases that reach the CCJ compared to those that go elsewhere, And therefore, in the extent to which that tapestry is being illuminated in those countries that enjoy the Caribbean Court of Justice as their final court of appeal. And we are here to serve those who are sending their appeals to us. And my view is that those who are not, they are missing out. I thank you.
Thank you very much, Mr. Justice Saunders, President of the CCJ. Near and far mindsets. It is now the time for another judge to deliver a presentation, and I'd like to invite Justice Hayton. Please. Thank you.
Well, good morning, dear listeners. I think I'll assume all protocols to have been duly observed, so we save time. So I've got time enough to get across to you some of the objective facts about the independence of the court. First of all, I'll start off with the CCJ Trust Fund and point out that, in fact, it is supervised, of course, by a body that is full of persons of honesty, integrity, and intelligence. The board of the trust fund that oversees it consists of the Secretary General of CARICOM, the Vice Chancellor of the University of the West Indies, the President of the Insurance Association of the Caribbean, the Chairman of the Association of Indigenous Banks of the Caribbean, the President of the Caribbean Institute of Chartered Accountants, the President of the Organization of Commonwealth Caribbean Bar Associations, the Chairman of the Conference of Heads of the Judiciary of Member States of the Caribbean Community, the President of the Caribbean Association of Industry and Commerce, and the President of the Caribbean Congress of Labor. So you can see there you have a very skilled, knowledgeable, independent board to look after the trust fund, which of course is crucial because that is what enables the court to operate efficiently. So this independently managed fund was started off with $100 million US dollars that was borrowed by the various member states, and it's been repaid now. And indeed, it's now at 87 million, despite the fact of an economic crash and that we've been going for over 14 years now, costing about 5 million a year. So that the operations of the court have been well funded through the fund's earnings, which of course are not just the income earnings, but also the proceeds of capital gains, which have helped to develop the fund, because we look at total yield, not just the pure income side. It's the income and the capital gains. And all the CARICOM countries contributed proportionately to their populations to ensure that the 100 million fund was provided, and so that the court doesn't rely on governments for continuous funding. So that's the trust fund. Now then, we have the Regional Judicial and Legal Services Commission, which is the appointing body and the body with powers of removal, and a crucial body for ensuring that we have judges of skill and integrity on the bench. They, again, are a distinguished group of persons. Of course, they are presided over by the court president, but then there are two persons appointed jointly by the Organization of the Commonwealth Caribbean Bar Association and the Organization of Eastern Caribbean States Bar Association, one chairman of the Judicial and Legal Service Commission of a contracting party, and you sit for 3 years with a rotation every 3 years in reverse alphabetical order or proper alphabetical order, depending what body you're chairman of. So there's also one chairman of the Public Service Commission of a contracting party, 2 persons from civil society nominated jointly by the Secretary General of the Community and the Director General of the OECS, and there are 2 distinguished jurists nominated jointly by the Dean of the Faculty of Law of the University of the West Indies, the Deans of the Faculty of Law of any of the contracting parties, and the Chairman of the Council of Legal Education. And then there are 2 persons nominated jointly by the bar or law associations of the contracting parties. So there's a distinguished group of independent persons, none of whom are politicians, of course, who are there to oversee the appointment and, if need be, removal of judges. Now, to become a judge here, you have to apply to become a CCJ judge, and there is a rigorous screening process with various background checks, and particularly there is an interview. So way back in 2004, a large number of persons were interviewed, persons locally in the Caribbean, and in fact persons outside the Caribbean. So I was in that cohort of 8, 1 Sierra Leone judge and 7 of us from England, who were flown over by Biwi on the Saturday, shown some of the sights of Trinidad, like the zoo, on the Sunday, and were interviewed on the Monday and sent back on the Tuesday. And I was fortunate to be one of the persons selected to be on the group of judges. And there is a wide range of judges, of course, that we have. The reason why so many people were interviewed locally and from abroad was that the idea was initially, and continues to be, to try and get the best legal brains available throughout the civil law and the common law world, so that you have a good range of persons covering all the subjects that are covered by the CCJ, because in our appellate jurisdiction there's a fantastic range of areas: commercial law and property conveyancing law, tax law, chancery law, trademarks, copyrights, and so on, private international law. And then on top of that, the key functions of this court are not just the appellate domestic jurisdiction, but of course also the original jurisdiction based on the revised Treaty of Chaguaramas. And so this is something new for the region, and so it helps to have persons experienced in regional public international law to help develop the original jurisdiction. So we do, in fact, have this very broad range of judges who, as to be expected, have absolute security of tenure, subject, of course, to being removed on grounds of misconduct or misbehavior by the RJLSC. We, in our working day, sit on panels of 3 or 5 or 7, that being determined by the President, depending upon whether it's a straightforward special leave application or a very major case involving often constitutional law of Guyana, for example, where we've had some decisions we've given and some that we are yet to give, which will be of particular significance. And as emphasized, we've come from a broad variety of backgrounds, and you must, of course, live in Trinidad if you're a CCJ judge. Many are predominantly from Caribbean countries, but the idea was for it to be possible for persons outside also to come and live in Trinidad and be CCJ judges. Of course, I'm one from England, although I did have the benefit of sitting as an acting High Court judge in the Bahamas in 2000 and 2001. So you have a group of us who, I'm delighted to say, through good appointments made by the RGLSC or by good luck, have actually worked together very well. We click well together as a group of 3, 5, or 7, discussing things together, and if we can come out with one judgment, then we prefer to come out with one judgment, because that's much clearer for lawyers and lay people. But of course, in the appellate jurisdiction, all of us are free to produce a dissenting or an additional opinion if we see fit. But on the whole, if we're not dissenting, we go for one judgment as making life easier and making the law clearer. And of course, to get to the CCJ, we've already have had distinguished careers when you look at the competition from the candidates for interview, and we've got to the stage where we're not persons who are in the law for the money. We, in a sense, could be said to be the archpriests of the law. We are here to develop the law, and basically the fascination of this court is we have the appellate and the original jurisdiction. So in the appellate jurisdiction, we're here to try and develop the law for the benefit of Caribbean peoples, and in particular, interpret the constitutions, because the constitutions are important in setting out the rule of law and setting out the full range of fundamental rights and freedoms, which, as our President indicated, are best determined by courts in the Caribbean rather than by the Privy Council back in England. And then on top of that, we work together to deal with the original jurisdiction, which, of course, has a long way to go for there to be a fully developed skeleton with plenty of flesh put on it through judgments of the court. And that is a particular important area for the development of the CSME. The CCJ is right at the core of it to make sure that the system works properly and enforces properly, and in the original jurisdiction we've shown how that works with the various remedies which will be shown to have been developed and under the revised Treaty of Chaguaramas, although it doesn't speak of any particular remedies. And we have the benefit of not just interpreting the treaty, but actually applying it. And in doing that, we can come up and make new law, like a limitation period for claims to recover tax that was unlawfully exacted. So there we are. We are working together independently to try and develop the local appellate jurisdiction for the benefit of the community and determine the extent of the rights, the rights and freedoms under the Constitution. And in the original jurisdiction, we are working together in this novel area, although, of course, we have some examples of other jurisdictions, like the European Community, to help develop the treaty. But, of course, it is in this context, in this Caribbean context. And with us, coming from a variety of backgrounds, we're always there to help one another and keep each other fully informed so we can come and produce very good judgments, which we hope will help to develop the destiny of the CSME, so that we do, in fact, have a good working economy in the Caribbean, so we have healthier, happier, and wealthier Caribbean peoples, we hope. Thank you.
Thank you very much, Mr. Justice Hayton. With the independence of the CCJ and the workings of the court, thank you very much for that. I'd like to invite now Mr. Justice Anderson to share with us some insights.
Thank you, Chairman. Mr. President, colleague judges, ladies and gentlemen, I've been asked to speak about the original jurisdiction of the Caribbean Court of Justice and regional integration. But as you'd have heard earlier, Ms. Choate, Senior Counsel and Independent Senator, has covered the field. So I felt like saying I agree entirely with what you have said, and I have nothing to add. I also noticed that Justice Hayton trespassed on the original jurisdiction as well. I'll have to speak to him about that a little later. I'm particularly pleased that Ms. Choate spoke about the cases, because I don't want to go into the cases. I want to sort of paint a broad brush of what we have done, what we are doing, and what we plan to do in the original jurisdiction. You will recall, of course, that the attempted political union failed with the demise of the West Indian Federation in 1962. And following up on that, there have been various attempts at regional economic integration, and these attempts have been underpinned by legal agreements. The first, of course, was in 1973 when we had the Treaty of Chaguaramas. And the Treaty of Chaguaramas created the Caribbean Community and also created the common market. Now, notice that these two things were created separately. So we had the community over here, and we had the common market over there. Secondly, another point to notice is that the common market was very modest in its attempt at regional integration. It covered only one facet of regional integration, which was the movement of goods. And a third feature of the early model was that there was no enforcement mechanism for the Treaty of Chaguaramas and the regime it created. I worked at the CARICOM Secretariat for a number of years, and it was an open secret there that the provisions of the 1973 treaty were honored more in the breach than in the compliance. And this was an open secret around the region. Member states would get together, they take decisions, but these decisions would not be, in fact, enforced. So there was a serious problem with the enforcement regime. Nonetheless, this regime existed for about 30 years, but in 2001, the member states got together and they adopted the revised Treaty of Chaguaramas, which created another model of regional economic integration. First of all, there was the community created by the treaty, but within the community was established the CSME. So we no longer had a community over here and a common market over there. We had both together. My friend and colleague, Justice Pollard, gave the example of the first regime, first model, as being a woman with child, and the second model as being a woman in child. Make of that what you will. The second model, of course, as I said, integrated both the regional economic integration arrangements into the community. Secondly, it expanded the range of things that were covered by regional integration, not just the movement of goods, but the movement of people, the provision of services, the movement of capital, rules to do with competition, rules to do with disadvantaged countries and regions, transportation policy, agricultural policy, subsidies. A whole area, a whole gamut of things were covered, which were excluded in 1973. And perhaps most importantly, and I'm biased in this regard, the revised treaty created, established, if you will, used the Caribbean Court of Justice as the enforcement arm, the hammer, if you will, for the rules that were established in the treaty regime. So the CCJ was invested with original jurisdiction to hear and decide disputes concerning the CSME. And by original jurisdiction, all that is meant is that parties could come directly to the court to have their grievances heard rather than go to another court first and then come to the CCJ. So the CCJ is the court with original jurisdiction. And that original jurisdiction was accepted as well in the agreement establishing the court. Now, this original jurisdiction is a very special jurisdiction, as you have heard before. It really creates the Caribbean Court of Justice as an international court, an international court that settles trade disputes between members to the revised Treaty of Chaguaramas. Now, that is crucial because there are some differences, there are some disputes, there are some controversies about the appellate jurisdiction. But as far as the original jurisdiction is concerned, there is no dispute. All member states have agreed that they will adhere to the original jurisdiction. That's, I think, very, very important. And in that jurisdiction, of course, we perform the role of an international court. We rely upon international sources of law to come to our decisions. That being so, the court has said quite clearly that it is the guardian of the treaty. It makes sure that the provisions in the revised treaty, the provisions setting up the CSME and so on, are in fact obeyed. In an early decision, given I think in 2009, the court said that by signing and ratifying the revised treaty and thereby conferring on this court ipso facto a compulsory and exclusive jurisdiction to hear and determine disputes concerning the interpretation and application of the revised treaty, member states transformed erstwhile voluntary arrangements in CARICOM into a rules-based system, thus creating and accepting a regional system under the rule of law. So we guard the treaty, we make sure that the provisions in the treaty are respected, that they are complied with, and we give life, as my brother Justice Hayton said, to the treaty. We make sure that the treaty has meaning in the lives of Caribbean people. Now, in doing that, we have done a number of things. We have answered the question, for example, who can bring claims before the CCJ in the original jurisdiction? Of course, member states can bring claims. The community can bring claims as well. But as we heard earlier, there's a very special provision in the treaty, Article 222, which allows persons to bring claims in the original jurisdiction. And these persons may be natural persons, or they may be legal persons, companies, corporations. For what can they bring these claims? Well, anything that's covered in the treaty. I mentioned freedom of movement of goods, provision of services, capital, and all of the other provisions in the treaty. So any of those persons can bring claims to protect the rights granted to them under the revised treaty. Well, what remedies are available when they bring these claims? And as we heard earlier, there's nothing in the treaty about the remedies which this court can grant in the original jurisdiction. This is something we have had to make up, if you will. But we have made it up based upon the sources of international law relevant to the adjudication. So first of all, parties have asked for a statement that the state against which I brought this case breached the treaty. And we have said, yes, we can grant that. So we have granted a declaration. We have said, yes, the state has breached the treaty. And then, of course, the parties wanted to go further. They wanted us to order the state to do certain things. And of course, the state said, but we are sovereign. How can you order us to do anything? And we have said, yes, based upon our analysis of international law, based upon the objectives of the treaty, we can order states to do certain things. So we have actually issued mandatory orders against states. But of course, you know, you give the litigants an inch, they want a mile. So they wanted more. Not just a declaration, not just the order, but they wanted damages. They wanted money, compensation. And of course, that is where the rubber hits the road in many instances. So the question arose, well, can the court order damages? That was something that was debated for some time, both in the courtroom and in the deliberation room. But the court decided, in the end, that damages could be awarded. And damages not just to compensate for loss suffered by virtue of the breach of the member state, but damages also to mark the fact that the state had done something wrong. The state had breached its treaty obligations. This is similar, perhaps, to vindicatory damages in constitutional law. But they wanted more litigants, not just damages, but they also wanted, perhaps, interim measures. Well, even before we have established the case to the satisfaction of the court, can we get an interim measure? Can we get something before the final judgment? And again, the court has said, in appropriate circumstances, yes, we can award, and in fact, we have awarded interim measures. Of course, it's one thing to give the remedy. The other thing is to make sure the remedy is, in fact, followed through, that it's complied with. Now, I'm happy to say that in terms of enforcement, all the judgments given by this court in the original jurisdiction have been enforced, have been complied with. Now, for those of you who are not au fait with international law, you may not realize the significance of that point. But in international law, one of the major weaknesses is that the judgments given by international courts are not enforced all the time. You might recall, those of you who are interested in the area, a case brought by Nicaragua against the United States before the International Court of Justice. And the ICJ held that Nicaragua was in fact entitled to damages and awarded damages against the United States. This was in 1984 or thereabouts. Those damages have not been paid. We have had situations where international courts have granted awards for over 50 years, which have not been paid. And therefore, the fact that all of our judgments in the international jurisdiction have been enforced, have been respected, I think, says a lot about the court, but also says a lot about the member states and the community against whom these judgments have been issued. We don't leave it up to the vagaries of the parties. The court establishes a monitoring mechanism. So once we have given a judgment, we follow up 3 months later, 6 months later, to make sure that the judgment is being complied with. If there's any difficulty, we seek to know what the difficulty is and seek to facilitate as best we can. So as I said, we have a 100% record, and we are very proud of it. There are many changes which have been brought by virtue of the exercise of the original jurisdiction. For example, following decisions we have given, CARICOM now has a better idea as to the procedures it must observe in relation to the waiver of the common external tariff. That is to say, if CARICOM wants to reduce the tariff on goods coming into the region from outside, it must follow certain procedures. And one of the critical things that we emphasized is that it must consult with the regional producers of the good, which is the subject of the importation request. So the court has set out quite clearly the procedures that must be followed there. Environmental tax was mentioned earlier. The court has made clear that individual countries cannot discriminate between their producers and other regional producers. So if there's an environmental tax on goods coming in from Suriname into Guyana, then there must be an equivalent tax on goods produced in Guyana by virtue of this environmental levy. Customs and immigration procedures, I mentioned that earlier. The court has stipulated that when CARICOM nationals are enjoying their rights of freedom of movement, they must be treated properly, with respect. Must be let in unless there are very, very specific reasons prohibiting their entry. They're undesirable persons. And there are not too many undesirable Caribbean nationals, I don't think. Or if they present a charge on the public funds, then. But even then, if they're going to be rejected, they must be given a reason in writing. They must be allowed to consult a lawyer or a representative of their consular office. So we have specified what ought to happen when persons are seeking to exercise their right of freedom of movement. Legislation barring homosexuals, the case we did some time ago mentioned by Dr. Rampersad. We have, I think, ignited a discussion around whether we should keep some of these pieces of legislation which date back to the colonial times. Right? And I think that discussion is ongoing. But I think what is also very important is that we made clear in that case, Tomlinson, that aside from how the region treats homosexuals from outside the region, member states cannot discriminate against our homosexuals. Homosexuals who are CARICOM nationals, they must be allowed entry as any other CARICOM national would be allowed. And we have also spoken about the rules of procedure of the Competition Commission. I think because of all of that, I hope, and I think, and I believe, reasonably, I hope, that there has been, in fact, a spike in the use of the original jurisdiction. You'll see that in the formative years, the number was pretty flat, 2, sort of. But last year, we had a bumper crop of like 7 cases in the original jurisdiction. Now, there might be particular reasons for this. We could go into that later on if you wish. But I'm hoping that as the community sees that we are proactive, as the community sees that we're making a serious contribution to the development of the original jurisdiction, that more and more persons are interested in taking their disputes to us. Finally, a couple of new developments to mention. One is that, well, first of all the cases we have heard so far have been brought by individuals pursuant to Article 222. We have not had a case brought by a member state against another member state, or a case brought by the community against a member state. All of our cases have been brought by individuals. But very recently, a few weeks ago, there was in fact a request for an advisory opinion, and that request came from CARICOM. CARICOM is asking us basically to indicate to them the procedures by which they can take binding decisions, and on whom would those decisions be binding? Only the states who vote for those decisions, or all states? So that is something that will occupy our attention very, very shortly. And the second development to mention is that there is room in the treaty to allow for collaboration between the CCJ and national courts and tribunals. CCJ doesn't sit on high completely isolated from national courts and tribunals. And what joins these two judiciaries, if you will, is Article 214. Article 214 of the revised treaty not only allows for, but requires that there be referrals from national courts to the CCJ when treaty issues come up in the national courts. They're obliged to refer those issues to us, and of course we will give an interpretation on the treaty provision involved, remit that interpretation to the domestic court, which will then decide the issue. So we see this as a possibility for collaboration and partnership between the CCJ and national courts and tribunals. The CCJ itself, through the courts, through the academy, and other means, will try to sensitize other judiciaries to this provision, Article 214. We have been promised some resources from the EDF, waiting to see that that promise is fulfilled. And of course, we will then visit the national courts to make sure that they are fully aware of the provisions of Article 214. And through partnership with the Council for Legal Education, we will also, of course, make sure that attorneys at law are sensitized to the referral obligation. I did not see your hand at the back, so I hope I'm okay. Thank you very much.
Thank you very much, Mr. Justice Anderson. And personally, the explanation of the original jurisdiction, I found, if I'm allowed to say, and I'll give my opinion, yes, I found that intriguing because there are certain aspects that, with the language of the court and the language of law, is not always immediately accessible to ordinary persons like myself. So, ordinary. Thank you very much indeed for that. Also, and further underscoring the significance of the CCJ as acting as guardians of the Treaty of Chaguaramas, and a point as well that Justice Hayden made, and how it impacts the everyday lives of all of us in the Caribbean, the significance of that. I'd like to welcome, please, Mr. Justice Witt, who's going to, again, go even deeper into some of the language that people like me have difficulty understanding. So, in anticipation of that, thank you very much, Mr. Justice Witt.
Yes, good morning, all. I'm asked to speak about the appellate jurisdiction of the court, which is, of course, more familiar to anyone, to everybody, because in that respect, the court functions as the final court of appeal, and all the CARICOM countries have and have had for a long time a final court of appeal, which we know is the one that resided in London. The court was established by the CCJ agreement, which is a treaty, And actually, all the CARICOM nations signed on to that treaty. So very often we speak about coming on board, that a country needs to come on board. Actually, they're all on board. They signed on to the treaty. A few of them entered what they call a reservation as to the appellate jurisdiction. A few smaller countries, and of course Suriname, which has a different system of law, a better system of law, but that is just my biased opinion. Now, 4 of these countries had the courage to implement what they had promised to do, which are, of course, Guyana, Barbados, Belize, and Dominica. The two bigger countries, Trinidad and Tobago and Jamaica, as I said, are on board. They signed on to the treaty, and they never entered a reservation. So in terms of international law, they are bound to do that at some point in time. Of course, that is law. That is not always reality, but this is the fact. Now, 4 countries, as I said, using the court as their final court of appeal, and we have seen a growing caseload. Last year, 34 judgments were delivered in that appellate jurisdiction. I think it was mentioned that in total the court produced 150 judgments. I'm told that actually that's 250. So quite a lot. Now, what is a final court of appeal? Well, that basically decides in last resort how the law in a country must be interpreted and applied. And in other words, it is the court's function to maintain the rule of law in a consistent and fair manner. But it is more than that. In the words of the American professor Roscoe Pound, the law must be stable, but it cannot stand still. Law needs to be developed, mainly, of course, by a legislature, but also in a different and more gradual way, perhaps, by the courts through their jurisprudence. In our case, that means Caribbean jurisprudence. But what does that mean? As the court once stated in a vision there, which is now reformulated, but it said its jurisprudence seeks to be reflective of our Caribbean history, values, and traditions. But at the same time, is to be guided and to be consistent with international legal norms. So this is an interesting position. So on the one hand, you have to take into account your history, your values, traditions, pretty local. On the other hand, you look up and you look at international legal norms. That is a position which the court has taken and which explains that not always the court can go this or that way and needs to find a golden way somewhere in the middle. And it is also a matter of slowly but surely progressing towards a certain point. In the end, all law, and this is putting it a little differently than the president, but it comes down to the same thing. All law results from the coming together of justice, clothed with the generally applicable attributes of principled fairness on the one hand, and the mainly local Caribbean realities on the other. That explains why the common law, for example, has stark variations. The common law of the United States is not the common law of Canada, and the common law of the United Kingdom is not the same as that of New Zealand or Australia. And so it is, or so it should be, with the common law of the Caribbean. We live in a different world, and we may apply the same high principles, but the result of that leads to differences in law. In order to be relevant, Caribbean law must have its own texture, its own colors, its own substance. However, without becoming parochial. We want courts to be accessible, affordable, and expedient. In other words, effective in their dealing with cases. And we think that we are. From its inception, the court has sought to combine the high principles of law with down-to-earth approaches. In our view, lawyers and judges should not let themselves be mesmerized by legal niceties and technicalities. Where reasonably possible, courts should deal with the merits and fairness of the cases before them, and they should deal with them quickly. In a very early case already, the court cited Justice Mosmano, who said the attainment of true justice is over the highway of realities and not through the alley of technicalities. I think this line of thinking has never left the court. It is not only in the jurisprudence of the court that it strives to be practical. That is also reflected in the way cases are managed and their handling is organized. We have created pragmatic rules of court to enable broad access to the court. These rules are updated every 2 years now. Next week we will launch the 2019 version of these rules, which will allow a further speeding up of the proceedings before this court. We want our procedures to be as simple as possible, and we are still seeking further improvement. Accessibility, affordability, simple procedures, and speed go often hand in hand. Accessibility, our court fees are relatively low, and our rules of court have provisions for so-called poor persons in civil cases. They don't need to pay fees and no security for costs. In criminal cases, no payment is required at all. From early on, the court has made use of modern technology, and thanks to our video conferencing equipment and the use of other techniques like Skype, parties and their counsel can access our court without leaving their country, and sometimes without leaving their chambers, or even sometimes even to without leaving their home, which has happened in Guyana on a national holiday when the court there was closed, usually in the local courts. That is where the video equipment is. On that day, there could not be access to the Court of Appeal in Guyana, and but the case was heard, and counsel was addressing us from his living room through video conferencing, Skype. That is nice. Of course, it is always nice to have these gadgets, but that's not the point. The point is that it gives very easy access and makes cases much more affordable, which is something we want to emphasize. People should not pay too much money to get justice. When the court was preparing its first strategic plan years ago, it consulted with all the stakeholders, and it then we heard that lawyers in Guyana complained about the high cost of compiling all the bundles, I think 7 of files, and then sending them to the court. Of course, there are 7 judges, so you need to compile 7 records, and in some cases that is a lot of paper. So if you have to copy all of that 7 times and then send them by FedEx, again, it is time-consuming, and especially it costs, again, a lot of money. Now, so when the court heard this. I think in 2013 already the court introduced the possibility of e-filing, where you could copy the record and the pleadings, etc., and send them to the court by email. This measure has saved the lawyers and therefore their clients, not only in Guyana, a lot of money. E-filing system was later replaced and improvised by the introduction of the paperless courier system, which makes the whole filing process even easier, and moreover allows the court a very strong grip on the incoming cases, and it allows the court strict management of these cases. The system also prevents, as it seems to happen regularly in our region, that case files disappear. They are there and they cannot disappear. For judges, court staff, and lawyers on all sides, the court file is easily and readily accessible at the click of a mouse, although a mouse also seems to be old-fashioned nowadays. The courier system further allows the court to take a very proactive approach with respect to the cases that are filed. Not every case requires the same tempo. There may be cases with preliminary issues that need to be dealt with immediately. You cannot always hear cases in the order that they are filed. Our legal counsel, young, very talented and hard-working lawyers who assist us in many ways, together with the registry, through this system, will be able to pick up these preliminary points or points of urgency quickly, and that allows the court to use that expression, to be on the ball. Talking about lawyers, because we are here as a court in the region and accessible, every lawyer in the region may have an opportunity to plead a case before his or her final court of appeal. And sometimes it might come as a surprise, they do it for free. It is not that usual that if you are a young upcoming lawyer that you can go to your final court of appeal. Certainly not if your final court of appeal is on the other side of the ocean. That happens here, and it involves the lawyers more in the development of the law. We also have seen cases where the local bar association in Guyana, for example, assisted poor litigants in bringing their case to this court for free. There is this well-known case of Ross and Sinclair, where two poor ladies had a dispute, a dispute over a house, which I don't go into the details. The point was they would never have gotten justice if they would not have been able to reach this court, but through the video conferencing system, through the fact that the Bar Association assisted both ladies with free counsel, the case was heard, and a very important point of Guyanese law was decided. Talking of speed, well, the case was mentioned, the Van Toes case, filed on a Friday, heard on the Sunday, and decided on a Sunday. Thankfully not on a Saturday. Now, this brings me to the broad spectrum of cases that the court has heard in the last 14 years. And I'm not exaggerating if I say that several of them were groundbreaking. I also have to remark here, there is this broad spectrum of cases. Many more cases will come from these countries that have accepted the court as the final court of appeal. Many more cases than before that time, because bringing a case to the other end of the ocean is a very expensive thing to do. The fact that the court is here, the court is so accessible, is doing its best to make things as affordable as possible, simply creates the possibility of getting more cases and more kind of cases to your final court of appeal. We all know that in criminal cases, for example, the cases that used to go to the final court of appeal those were the death penalty cases. But there is more between heaven and earth than death penalty cases. There are many important criminal cases that actually need to be decided by a final court of appeal, and that was not possible. But for those jurisdictions that took this court as their final court of appeal, that became a possibility, and that can be shown. As I said, there's a broad spectrum of cases: constitutional and administrative law, criminal law, civil law, land, commercial, and tort, indigenous rights law, at least in the Maya leaders' case. What you will see in those cases that those cases brought certain points to the fore that needed to be decided and were decided and really had a huge impact. Just take the Romeo da Costa Hall case. That was about crediting time spent on remand. Now, at first sight, that might not be a very popular decision, but in fact, that is not so important whether it's popular or not. The point is this, that if you are a poor person, you cannot pay for your bill, and you have to spend 2, 3, 4 years on remand in order to get your sentence. And your friend who had enough money to get bail, to get the same sentence, then you are spending years more in prison as a poor person than the person who could afford a lawyer and bail. That is simply unjust. And the fact that it takes so long nowadays to get a criminal case heard, and in Trinidad and Tobago it has even reached absurd proportions, if I may make that comment, then really that kind of delay endangers the very fabric of society that has nothing to do with justice anymore. And at least if you can deduct the time spent on remand from the sentence that is given to you, at least that restores to a great extent, not a complete extent, some form of justice. That still leaves, of course, those cases where people are innocent and have to wait for a very long time. The court has made some inroads there, but I suspect more cases will be coming to materialize further thoughts in this respect. This decision of Romeo da Costa Hall, it was interesting. It was not only impacting the practice of criminal law in the 4 jurisdictions that belong to the court. They impacted all the jurisdictions of CARICOM. In Trinidad and Tobago, the Court of Appeal adopted that position. In Jamaica, the Court of Appeal adopted that decision. In the Eastern Caribbean, the Court of Appeal there adopted the position, da Costa Hall. There was an earlier, somewhat vaguer decision by the Privy Council in Mauritius, and of course, a later decision referred actually to our decision too. Point is that when we gave that decision in Romeo da Costa Hall, it was finally accepted by all the courts in the region that there should be a deduction of time, or at least a crediting of time spent on remand. It has nothing to do with reduction of sentences. It has to do with acknowledging realities. The word reality comes back. The reality of being somebody in prison for a very long time, waiting to get a final decision. In terms of criminal law and also, of course, constitutional law, there was this case of Nervais and Severin, which dealt with the mandatory death penalty in Barbados. It is interesting to go to the reasoning in that decision, as well as in the McEwen case that was mentioned. You will see that actually the court reaches a conclusion that totally comports with the international legal norms in this respect, but going into the colonial origins of certain legislation. Any other court would never do that, but this is a court which is situated in this region and is able to look at it from that perspective. Further, there is clearly an impact of that decision because recently there was a constitutional amendment in Barbados which actually acknowledged that there is still a death penalty, but it is not mandatory anymore. The case of this particular case and also the Boyce case that was mentioned was recently cited by the Privy Council in a case from Jamaica, where they more or less followed the approach of the court in the interpretation of the word whereas, which they before that had a different opinion about. So the court makes its way and is influential in that respect. There is, of course, the development of the regional of land law and commercial law, where, especially in Guyanese land law, the court has given judgments that clarifies that part of the law, important part of the law, and some of the decisions also reflect on land law in other parts of CARICOM. In commercial law, the court in several judgments has clarified certain issues. Then we have the Maya leaders case, which was, as was mentioned, about the customary land rights of the Maya people, the indigenous people in Belize. What is interesting, apart from the point of principle that was expressed, and there we go back to my point that the court really wants to be pragmatic and wants to get things done. Justice Anderson spoke about the monitoring system that the court developed in the original jurisdiction, which is in fact something that you can see, for example, in the Inter-American Court of Human Rights. That is a method that is not unknown in international law. But what the court did in this Maya leaders case is to transplant that kind of method and make it part of the common law, if you wish. And the court is monitoring the implementation of those highly important principles that were formulated. Now, it's one thing to formulate nice and beautiful principles. It's completely different thing to implement that in the realities of life. The point is that the court has called these parties several times back. They report to the court willingly, and in the last report, it was even expressed a gratitude that the court took this lead because this is the only way to get things done, slowly but surely. So you can give the nicest judgment in the world, but if there is no implementation, if there is no pressure, if there is no guidance by the court, then it will not happen. So this is a novelty that we have seen developed by the court. It's quite unique, certainly in a common law setting. And last point I want to mention, that is this case, malfeasance in public office. That is a Belizean case where the court, and this was again novel, allowed the state to sue former ministers who were supposed to or alleged to be corrupt and to sue them for damages. in the tort of malfeasance in public office. This was the first case in its sort. There was quite a discussion in the court. It was a 3-2 decision, and I must say the dissents had important points, but in the end, the court decided that it must be possible, there must be another tool to fight corruption, and that this particular tort could be used. And I've seen literature and in Australia and in England really praising the court for this particular step. And of course, corruption in government or political corruption is something all the Caribbean states are dealing with, or at least they are struggling with it. I'm not so sure how far they are dealing with it, but at least there is an extra tool now in the arsenal of legal remedies. This is just to give you an impression of what the court is doing and the impact that the court has in the further development of the law. Thank you very much.
Thank you very much, Mr. Justice Witt, for that clarity, bringing us up to date with some of the issues that the court is dealing with and how they impact us in our day-to-day lives. And we will be hearing from one more judge before we go into our question and answer session. So I'd like to invite to address us, please, Madam Justice Ranjanatha Lee.
Thank you, Garfield. Yes. Good day. It's after lunch. Good day to all, President, colleagues, and distinguished ladies and gentlemen. President, allow me to borrow from what you said. I want to say good day to all who are seeing us from near and those who are seeing us from far. So I am going to share with you the CCJ's role in regional justice reform and outreach. The old traditional idea of a judge was one sitting high up and sitting in court, hearing cases and delivering judgments. But the CCJ is a court with a very different mission as well. CCJ is committed to improving justice delivery in the region. And the court and the judges of the court play a key role in regional justice reform and outreach. So what I intend to do is just give you a snapshot of all the work that we've been doing over the past years in justice reform, in improving justice delivery in the region. The CCJ have put up something that deals with jurists. I don't know if you can see it properly. Judicial reform and institutional strengthening, the Jurist Project. And I'll speak to that now. The CCJ in its mission statement has committed to providing accessible, fair, and efficient justice for the people and states of the Caribbean community. The CCJ was therefore a natural fit, I like to call it, to execute the Jurist Project. And what is that Jurist Project? The Jurist Project is a regional judicial reform initiative funded under an arrangement with the Government of Canada. The project is being implemented by the court, the Caribbean Court of Justice, which was appointed by the regional heads of judiciaries as its regional executed agency. So ladies and gentlemen, far and near, anytime you see jurist, think about CCJ, because we are really the regional executing agency. The main aims of the Jurist Project, to simplify it, is to eradicate delay and improve efficiency and responsiveness in Caribbean justice systems. And a little snapshot again, or as the young people would say, I'm sending you a screenshot. A little screenshot of the work being done under Jurist project. You would see it, Regional Model Guidelines for Sexual Offenses. Sexual Offenses Model Court established in Antigua and Barbuda. Development of a bench book for magistrates and parish court judges. These would be judges, magistrates and parish court judges across the Caribbean. This book is at present 800 pages. We are about to go to publication. So we're very excited about what this will mean for those who do so much of the judicial work, the magistrates and parish court judges. Of course, we donated technology to Dominica, Guyana, Jamaica, and we played a key role in the development of gender equality protocols for the judiciaries. They have been launched in Belize and in Trinidad and Tobago. I want to spend a little time on the guidelines and the model court for sexual offenses, because you would notice an emphasis on those things. And you would say, why an emphasis on sexual offenses? We were sitting because we had consultations with people, survivors, people who had been children when they were raped. We had consultations from Belize, coming right through the Caribbean down to Guyana. We met with indigenous people who were also survivors of sexual offenses. And in one case, a very good judge shared with us this. She said, I thought there were too many sexual offenses cases lying down and in backlog and delay. So I pulled them together and I put this one on early. And young lady had been raped at age 12. She was now 28. And so I called the matter. And when I called it, she said, I'm not continuing. She said, I can't continue. I'm married. I have children. And I think that when I heard that, it made us all in the room, I believe, and all of us here together understand how important it is that we can eradicate delay. I think delay is the enemy of justice. I've said it right through the Caribbean each time we spoke about our model guidelines, about our model court for sexual offenses in Antigua and Barbuda. And it's even worse to me, as I have seen survivors of sexual offenses wait 10 years and 15 and 20 years to get a trial in court. So that this is a key aspect of the work of the court. We are very committed to it. On the right side of your screen, you will see what the CCJ has done on its own. This is not with jurists. We've trained a new civil procedure. We've trained judges in the new civil procedure rules in Guyana. We've supported Suriname judges in the development of a judicial code of conduct. So these are just a few of the things that we have done throughout the region. And of course, in our work to bring reform, to improve justice delivery, we have done two things that I believe are still in one. We've established a CCJ Academy for Law. I say up front, if you want to have Justice Anderson speak to you for at least 3 hours, speak to him about the Academy for Law. Something seems not quite right with what is there, but what the CCJ Academy for Law is, it is an educational arm of the CCJ. There is an emphasis on international and comparative law. The Academy hosts biennial educational conferences, workshops, seminars, and it's wonderful that the Academy is open to legal fraternity, to academics, and you would see underneath the ccjacademy.org. That is the website. Please check it out. You would see the fine work being done. Justice Anderson has circulated to all of us the work plan for 2019. To describe it as ambitious is not to do it justice. So keep an eye on the CCJ Academy of Law. On the right side is the Caribbean Association of Judicial Officers. Our president has been chairman of that organization for a very long while. It's open to all judicial officers across the region. It works with regional, international organizations. It hosts biennial conferences. We're excited that we're going to Belize later this year. It publishes a newsletter biannually. And again, check out the website, thecajo.org. It is such a wonderful group of judges who are interested in improving themselves to better deliver justice to the people. And again, I highly recommend that you keep an eye on what we call CAJO. Yes, and of course, the CCJ also has several outreach activities. You will see there our president, and I believe those are the winners of our latest moot, the Hugh Wooden Law School mooters. They did an excellent job. They are our 2019 winners. We have had moots since 2009 annually. Again, if you want Justice Hayton to speak for another 2 to 3 hours, ask him about the CCJ law moots. We've brought students from right across the Caribbean, from every tertiary institution that deals with law. I think this year we had a bumper crop of mooters here, and it was really an excellent 2 to 3 days. The court participates in public education activities throughout the region. The court live streams its cases and important events like today. The court has developed an internship program for law students. They visit the court and they spend so many weeks with us working under a CCJ judge. We have a program where young, talented lawyers serve as judicial counsel to the judges. These counsel go on, they go to do their masters at wonderful institutions around the world. They come back to the Caribbean because they learn to serve the people of the Caribbean from the judges of the CCJ. And of course, we host eminent international jurists. We host law students and students from various schools and universities. We host also as well, judges have a monthly luncheon, and we host both local and regional and international visitors who are in themselves well-known and notable people. So we have the outreach activities. Those are just a few of them. And of course, the court is an itinerant or traveling court. It means that it can operate in any of the contracting parties. It can travel and sit. The court has sat in Antigua and Barbuda. It has sat in Barbados, Belize, Guyana, Jamaica, St. Vincent and the Grenadines, and of course we sit regularly in Trinidad and Tobago, the seat of the court. And as we close, and you've heard so much about the Maya case, that was really my first major case. I had just become a judge, for those of you who remember, when our then president, Sir Dennis Barron, says, "You're going to Belize," just about 2 to 3 weeks after. And among the cases that we did there was the Mayan case. And the court was absolutely packed. I remember our registrar running all over, looking for chairs and looking for every possible space in the court, because there was so much interest. Because here were the Mayan people seeing the highest court of their land dealing with something which was of great concern to them. So I can tell you that made an impression on me that I've never forgotten, that what we do as judges above all is serve people. So thank you. I hope this has given you a better idea of the role that the court and the judges have played in judicial reform and the very many outreaches that we have as a court. Thank you very much.
Thank you very much, Madam Justice. And now we will open the floor, figuratively speaking, for some question and answers. And I believe we have some from the region, from our live stream, and Charmaine will convey those.
Only 2 women have been on the court in the entire history. What would you attribute this lack of diversity to?
If I could take that question, I agree that of the 11 judges who have been sworn in as judges of the CCJ, only 2 of them have been women, and that is regrettable. Certainly the proportion of women to males in the region is a lot more than 2/11, is about 50%. But I think that there are also historical reasons for this. Typically, the judges who are appointed to the court at this time are judges who would have been trained in the 70s or even perhaps the early 80s. And at that time, in the law schools, the proportion of male to female was a great imbalance in favor of males. At this present time, that proportion has reversed itself dramatically, so that I have no doubt that in another 15 or 20 years' time, we would see far more women than males on the court. But the court does appreciate and is very interested in ensuring that there is, even at this time, a greater gender balance. And as I think was pointed out by someone earlier, at the level of the staff, and the senior staff in particular, there is a greater proportion of women than men on the staff of the court.
The president made a point about seeing from near. Why aren't more Caribbean people then using the court?
Yeah. I think it's a combination of different factors, many different factors. The one that I like to zero in on is that there is a wide gap, a wide chasm between perceptions about the court, and I think both Ms. Choate and Ms. Rampasad, Dr. Rampasad, dealt with that issue, if I'm not mistaken. There's a wide gap between the assumptions people make about the court, the perception they have about the court, and the reality of the court. I was extremely pleasantly surprised when the former Prime Minister of Barbados made some not very complimentary statements about the court. I was extremely pleasantly surprised by the outpouring of outrage about those comments from the people of Barbados. And that outrage was based on their experience with the court, their direct experience with the court. Unfortunately, the countries of Grenada and Antigua and Barbuda, where there were referenda that did not support the court, those people don't have the same direct relationship with the court. And so a lot of the views that you heard being expressed and which were reflected in the votes that were tallied were based on statements that really were at variance with reality. You heard statements to the effect that the judges are being handpicked by the politicians. You heard statements that suggested that the court was not an independent court. You heard statements that suggested that somehow the court was under the thumb of the politicians, of the political directorate. Now, none of these things is true. And I think they attest to the amount of work that the court has to do in order to better inform people, in order to ensure that our work and an assessment, an objective assessment of our work is better known throughout the region.
Okay. Why is there only one judgment in the OJ?
Yes, well, as the president just said, there's a difference between perception and reality. The perception might be that there's only one, but in fact there have been 21.
No, I think the question was related to right, that's no
Well,
dissent.
in that sense. Ah, okay. Now, that's an interesting question. I, first of all, should make the point that this is the same position in the European community, now the European Union, that there is only one judgment given in original jurisdiction matters, if you will. I think the rationale behind it is that, particularly at this early stage of the development of our community, it is good if the judges could speak with one voice in relation to regional integration matters, because of course these are judgments which will be directed at member states. If it's possible at all to avoid dissenting judgments in that situation, then I think that that is desirable. Even though there's just one judgment, that is not to say that the individual judges do not have a chance to put forward their points of view. And almost invariably, or I would say invariably, what happens is that there is a consensus which is arrived at, which represents the judgment of the court. So it's not as if a view is being stifled. All the judges have an equal chance to contribute to the discussion, and then there is one consensus judgment which represents the views of the bench.
I think this one is yours to judge. What do you attribute the rise in the OJ cases to?
That we're becoming better known, that our judgments not only stand the test of time, but are beginning to attract the attention of the actors in the region. I think that there is a wide scope for the development of the original jurisdiction. And I think the more that our consumers become aware of the work that we're doing, is the more cases that will eventuate in the original jurisdiction. I repeat what I said earlier, that it is, in a sense, a blessing in disguise, if you will, that individuals are allowed to bring cases before the original jurisdiction. If we had to depend upon member states, we probably would not have any cases at all. I, and I'm sure many other people as well, are very, very well familiar with the fact that sometimes our governments complain that other governments are breaching the treaty, but they will not take a case before the court. And of course, that is a matter for them to decide upon. But you know, the longer the time elapses, and the more cases we decide, I think more and more the work of the court will become known. And as I indicated earlier as well, in recent times we have had an expansion in our jurisdiction in the sense that we now have a request for an advisory opinion. Hope that's the start of good things to come.
And I think this is for all the judges. What is the process for decision-making, discussions, emails, and who decides who finally writes?
Justice Ritz, do you want to deal with that?
Well, it very much depends on the case. After we heard the case, we will have our first deliberations, and that from there it appears whether we all agree or not. Sometimes that's not clear right away, but in most cases it is. And if there is a majority or if there is unanimity, then the presiding judge will consult with the other judges and designate one of the judges to write. If there is a majority and a minority, then of course the majority will take it upon itself to decide who will ride, and if it is a minority of one, then, well, that doesn't, is not very difficult then. But if it is a minority of two, okay, they will probably decide among themselves who will ride a minority judgment, or they do both.
Okay. Someone is asking about leave to appeal as a poor person. How is that determined?
Well, there are criteria for deciding whether somebody is a so-called poor person or not, and they are to be found, I think, in the rules. So it's a certain maximum of income during a year. If you have less, then you are considered to be a poor person. And in that case, you don't pay fees, and you don't have to put up a security for costs.
Okay. Why?
Usually, of course, usually there needs to be some evidence of that income, affidavit or otherwise. Yes.
Why are more corruption cases, or why aren't more corruption cases being brought?
By whom?
Yeah, we don't know. We just deal with those that come. But the thing is that cases in the appellate jurisdiction do not start at our court. And invariably cases that deal with corruption would be cases that start at the domestic level. So that if those cases come before a magistrate or a judge, then it is always possible that they can come right up to the CCJ if they are started in Dominica or Belize or Barbados or Guyana. And we deal with them if they come up through that way in those states.
All right. How can delay be eliminated in the region? That's the last question.
Delay. These are some tough questions.
Of course, there is no magic thing to deal with delays, certainly not as it is now. What needs to be done is, I think, procedures could be simplified more than they are now. They are sometimes very complicated. I'm looking at this from the position of a civil law jurist. In our, let's say, system, things are much more simpler than in the common law. We don't have juries, for example. But that is not all. There needs to be a good case management of cases. Cases can be decided very often in a more summary way than they are now. Judges don't have to write treatises. They can be shorter in their judgment, to the point. That works because I come from a jurisdiction where that is the norm. So there are many, many ways of dealing with the delay. One thing is for sure is that the delay as it exists now in the region is absolutely detrimental to a system that we want to call a justice system. There's no justice with that much of delay, because the example that Justice Ratchnotly mentioned of the lady that was raped when she was 12, and the case will be heard when she's 28. Everybody understands that there can be no justice for this lady having to go through all these things again. There can be no justice for even the perpetrator, who might have been a bad boy then and now a decent man with work and family, etc. So delay, and there are many, many, many examples to be given. Delay is really what makes the justice system in our region problematic. Courts can do their bit, lawyers can do their bit, but I also think legislatures must do their bit and really getting together to find some way of reducing this delay. There are many methods which can be used, and they all have to be used. We cannot continue like this anymore. That is the only thing I can say.
I would just like to add to that, if I could list some matters which impact on delay. One is the effective use of appropriate court technology. You can't continue to have judges handwriting notes of evidence. And you need to use modern information technology in an effective way. Secondly, you need to have effective judicial leadership that establishes court performance standards and that monitors and ensures the observance of those standards. And thirdly, you need to interrogate the rules and practices that currently govern your court system and whether those rules and practices are in sync with modern methods of management and of court administration.
Might I add to that? An individual judge must take great care over the cases where he has judgments waiting to be delivered. I think once you start as a judge, you've got to try and keep in control of these judgments so you get them out normally within 3 months. And to that extent, you need to liaise with the Chief Justice who is managing things, because you will need a certain number of days off as writing days. You can't sit as a judge 5 days a week and expect to be writing judgments every weekend. But the main thing is to be very careful with how your delayed judgments are building up. Because once they do become extensive, it gets very difficult to get on top of them. So early on, you've got to watch what the signs are and be prepared, I think, also to give more oral judgments. Make notes as you go through during the day, and maybe after the hearing, make 1 or 2 notes, so that when you get to the end of relatively short cases, you can actually give a judgment.
I believe that's all the questions, or do we have? Absolutely, absolutely, absolutely. Please.
Just a comment on the malfeasance on public office. Marin and Coy could serve, we don't know why, and I think it's a great thing that we've had this case come forward, but could also serve as a deterrent to some of these states ascribing to the appellate jurisdiction of the court. The other question is, I was very impressed with Justice Rajnath Lee's presentation. We've been grappling with this issue of judicial activism and the CCJ from an academic perspective. And I think I've interviewed some judges on this, and it came up in the conference in Chicago. It was an issue that we discussed in the presentation. And what you have described to me suggests that the court, and judicial activism is not necessarily something negative. What you have described to me is a very highly judicially active court. And I really want to commend the court and laud the court on all these extra, if you want to say, extra judicial activities outside of the courtroom, because it's really service to the Caribbean community, service to the region, and service to the national communities, particularly to the underprivileged. So I want to commend the court highly on that. Thank you very much.
Thank you.
Okay, thank you. The next item on the agenda was the courtroom tour, the possibilities or the likelihood of seeing what's behind the scenes, especially some of the innovative technology that helps reduce some of the delays that have been experienced elsewhere. And I'm going to defer to Charmaine to organize the logistics of that. Right. But I'd like to firstly, if I may, thank the judges for their presentations and for some of the questions that came in that were interesting, and the judges' ability to handle those questions and I think provide answers that actually made sense. And I'm not saying that to be funny, because oftentimes difficult questions produce answers that deflect. And the answers were on point and much appreciated. So thank you, judges, and I'd also like to say a very big thank you for those who have been with us live on the stream and those of us in the room. And I'm not sure, if I'm out of place, please tell me, Charmaine. The tour that's going to happen, is a camera going down so that the live stream people can also take part in the tour?
Right, so there is going to be a live stream of the second part of the presentation. So we're going to ask for people, because obviously we've been sitting in here for a while, to take a break. And so if you need to use a restroom, snacks are still outside, and you can also have a coffee, which I know many of us need, so that if we can do that, and the camera will go downstairs and the live stream will continue.
Thank you very much. So do join us in a couple of minutes to continue with the live stream as the tour of the courtroom takes place.